Well, thanks for staying with us on the program this morning. Our next conversation is one that borders on social justice. Now, a sensational case had made the rounds where a core member was killed and her body dismembered, allegedly at the time by a 32-year-old gospel singer, Timileyin Ajayi. Prosecutions began, and yesterday, judgment was passed in one that saw capital punishment meted out on the accused. This morning, we joined State Counsel to the Nasarawa State Government, the Ministry of Justice rather, Mr. IRaymond Anzaku, who joins us virtually from the state capital in Nasarawa. Good morning to you, Mr. Raymond, and welcome to the program.
Good morning. Thank you for having me.
Now, Mr. Raymond would like to find out, starting from the judgment that has been delivered in this case, how much of justice for the late Salome Adaidu is this?
Well, in terms of reciprocal punishment, I can categorically tell you that can equate what happened to her, given the evidence that was adduced in court, to the punishment prescribed for him. For example, the evidence we display before the court shows our body dismembered into several pieces, amounting to about 50. And then here you have him being sentenced to death by hanging. So you cannot equate the two, but all the same, for us, and then for the society at large, we believe that justice is well served by the judgment, and then the defendant, Timileyin Ajayi, got what he deserved, and in view of the gruesome manner in which the crime was committed against the victim.
Now, Mr. Raymond, the challenge whilst this case was before the courts and on the trial was a position of Timileyin Ajayi, who vehemently pleaded not guilty despite the overwhelming evidence before the court. During the course of the trial, was the intent, or would I say the motive, finally discovered?
Well, there are two things. First, it is the provision of the law for such offenses. Any offense that carries the punishment of death, even if he had pleaded guilty, the court is under a duty to, record a plea of not guilty to him. The prosecution is at all time required to always prove a case of culpable homicide against a defendant. Now, it is within his right to prove or to plea not guilty. It is also within our duty to prove the case against him. In the course of trial, actually, what we've been able to decipher, for us, we are not looking at the motive. The motive is not the basis upon which the court convicts. The court is only interested in whether the person accused actually committed the crime. One interesting thing is that during the course of trial, the defendant, alleged that, in law we call it blackout, that you cannot recall what happened. All attempt to make him speak as to the facts, he decided not to reveal the actual situation that happened, in that room. However, we were able to, from circumstantial evidence we gather from, pieces of events, we're able to now have a connected fact. Now, we have one of the primary evidence of actually what transpired was what he told the police before trial. In his confessional statement to the police, he detailed the circumstance and what happened in that room. From what we gather from the confessional statement, she came to his place, they were together, he saw her chart, then she was taking a bath, and then he went into the bathroom with a knife. and then decided to slice her throat. So that's the evidence we have as to, so his motive will be that, we can only guess, but from the facts, his motive is as a result of, being jealous. That's what he tries to portray. But for us, that's not the most important thing. The most important thing is for us to prove that he actually committed the alleged crime. And that's what we've been able to do in court.
Now, Mr. Raymond, whilst this trial was ongoing, there were also concerns from members of the public who were watching on when the defendant at some point decided to claim that he had experienced some mental breakdown and was not in his clear mind at some point during the trial. In terms of that conversation, how did the courts proceed in that regard?
Well, he actually made that assertions. However, it is our duty to be able to disprove that assertion, and we did that. We've been able to, elicit from the defendant the one basic fact. He admitted during cross-examination that he is a person of sound mind and intelligence. And then two, he was able to give us accounts of, where the time the victim visited him, what they did, details, events of what happened between them, but then was trying to now dodge away from telling us how he did the act. Now, what we have was we were able to now, get that fact. Well, the law is clear on this. Having admitted that you are a person of sound mind and intelligence, you are duty bound to, reveal the circumstance of how the victim died. Because one thing is with that position, that he was the last person seen with the deceased. And then he also admitted that when she visited him, he locked his room, with an iron bar, and that it was only the two of them that were inside the room. So in a circumstance where you are last seen with a person, and the next day the person is now found in 6 different polythene bags, severely dismembered, who bears the duty to explain the circumstance as to how that person was found in your room in that manner? I think so that it's an established principle of law that we just have to apply, and the court rightly applied that principle to say, well, Mr. Timilayi, you being the last person that was seen with Salome Adaidu, you owe the court and yourself the duty to explain the circumstance of our death. And then telling the court that you can't remember is no explanation at all. It's not a reasonable explanation that is tenable in law. It's not tenable in fact and in law. And that it forms a basis. There was a duty imposed on him to explain to us. What we did as prosecutors was to establish certain facts. First, that this person was with you, which he admitted. She was with you all through the night, he admitted. And then she was found in pieces in your room. So the evidence that was not contradicted by the defense. And then, so the duty now moves to him to explain how this particular person was found in this manner.
Now, Mr. Raymond, talking about the charges that brought about this conviction, he was charged with 1 count of culpable homicide, contrary to Section 221 of the Penal Code of Northern Nigeria, and which is punishable by death. Now, with carrying out such judgments of the court, many conversations has been the role of state governors in signing off on the death warrant. Would this be seen to impede the delivery of justice, or would this conviction be carried out within this calendar year? Hello, Mr. Raymond. I don't know if you got my question. Well, the conversation with the State Counsel, Ministry of Justice in Nasarawa State, Mr. IRaymond Anzaku We did suffer some technical difficulty in getting feedback on my last question, speaking to Mr. Umar, who is the State Counsel of Nasarawa State Ministry of Justice. But we have been able to make grounds on the fact that the 32-year-old gospel singer Temileyin Ajayi has now been convicted on one count of culpable homicide involving the death of Salome Adaidu, who was gruesomely murdered and dismembered, much like Mr. Raymond has told us this morning. Whilst we're waiting for Mr. Raymond to rejoin the conversation, we'll also take a listen to parts of the reports filed in by our correspondent in Nasarawa, who covered that court proceeding that brought about the said judgment. And when we come back, we'll continue with Mr. Raymond Umaru.
It was a tense atmosphere at the Nasarawa State High Court in Lafia as Justice Simon Aboki delivered the long-awaited judgment in the murder trial of Temileyin Ajayi. The court found Ajayi guilty of killing and dismembering Salome Adaidu, a 24-year-old National Youth Service Corps member who had visited him at his residence. During the trial, the prosecution, led by Barrister IRaymond Umaru, presented compelling evidence including video recordings, 6 polythene bags containing body parts, a severed head, cutlasses, knives, and the deceased handbag with personal items. All were admitted as exhibits from the first day of hearing.
We are able to provide circumstantial evidence which actually goes to show what transpired. So the court looked at that and also considered his confessional statement to the police, which is even the legal evidence that we are required to tender. So, and then those are the basis upon which the court made this pronouncement. First, there are sufficient circumstantial evidence that led to the conclusion that he actually killed Mrs. Salome, and also his confessional statement to the police, which was tendered without objection.
Justice Aboki ruled that the prosecution successfully proved the case beyond reasonable doubt and sentenced Ajayi to death by hanging. He has 90 days to appeal the judgment. If no appeal is filed, the Ministry of Justice will forward the case to the state governor for assent. On his part, Defense Counsel Dr. Umaru Yunusa of the Legal Aid Council of Nigeria acknowledged the judgment, stating that the legal process was duly followed.
The law has taken its course because of the peculiar nature of this case and the accelerated hearing it was given by the judiciary. We have no option. We are lawyers. We only assisted the defendant in presenting his case. The duty to decide the case either way is the exclusive prerogative of the court, and that is what my lord has done, analyzing critically the evidence of both parties.
For the family of the late Salome Adaidu, today's judgment offers a measure of closure.
But this journey, I was trying to make sure that we get to this point of judgment so that the remaining youth, their life will be safe. Because if we allow this kind of person to continue in the society, it will continue to cause more harm to more living souls. And that is why I am happy that he was sentenced to death by hanging. And also I want to appreciate the state government, the High Court, Lavia, the judge, and all the media houses for all their assistance from the beginning of this case to this time. And also appreciate Nigerians for being there for me, for being against things that is not good.
With the final judgments now delivered, the case marks a significant moment in the state's criminal justice history, sending a strong message against violence and impunity. Mary Ojiji, reporting for ADBN News.
Now, Mary Ojiji, our Nasarawa State correspondent, followed that case and has also filed in his report on the final judgment. Will now rejoin the State Counsel, Nasarawa State Ministry of Justice, Barrister IRaymond Umaru, who was earlier on the program before the network did interrupt. Barrister Umaru, welcome back. Hello, Barrister, can you hear me? Do well to check that you're not muted at your end, or if it's the network, then...
Hello?
Yes, I can hear you now.
Yeah. So, Flo, going back to your last question.
Yes, sir.
Yeah. He has a right to appeal the judgment within 90 days. And then we wait, and then we'll give him the opportunity to exercise that right. But however, the governor, our governor is a respecter of the rule of law, and we believe that he will do the right thing with regards to the judgment. The Honorable Commissioner is on top of the matter, and he will be briefing His Excellency soon, and then we will make recommendations for His Excellency to, execute and sign the death warrant, so that the judgment of the court will be given life. We don't intend to have just a paper document. We want a document that will be implemented to the fullest, so as to serve as a deterrent to future occurrence from prospective, persons, defendants who might want to engage in such nasty and devilish acts. So within the level of the government, we are looking forward to implementing the judgment of the court.
Now, Barrister Raymond, we also listened to the lead for the defense counsel, who was much, would I call it, much at peace with the judgment as delivered by the judge. Now, from the defense perspective, during the trial, many say that did they really present a case for the defendant?
Well, they did. Naturally, it is our duty to prove the case against the defendant. It is not for him to prove his innocence. However, we were able to, adduce sufficient evidence which require him to respond to. And in the absence of such response, the court with no option than to take his decision based on the evidence before him. Now, what the defendant did was try to, raise a defense of blackout. And doing so is also duty bound, to support such defense by other sufficient facts, which he has failed to do in the instant case, because he informed the court that he cannot remember only that particular event. So we have evidence to show that you did the act. You don't have evidence to show that I did not do it. You are only telling the court you can't remember doing it. So you not remembering or recalling the act does not, protect you from, the fact that you did the act. So not recalling is different from doing the act. So what we have was that in actual fact, the evidence was overwhelming. The evidence, there were digital evidence which he saw that he could not contradict. At the time, for us, we feel the judgment was right and it was actually based on the facts. The defendant, in his own, it is natural for him to feel aggrieved. However, justice must always have his way.
Now, Barrister Raymond, let's talk about the implication of this judgment on the family and the larger society who are looking from the outside. We had listened to our uncle speaking to our reporter, but you have been much in contact with her extended family as well. Can you tell us their reactions and give us more insights on what you hope this would play in the larger society?
Well, their reaction, I can see it, when the judgment was delivered. I saw them, they were all happy, and then they were relieved. The sister, I saw her, she looked relieved, even though, nothing can replace Salome, but she was relieved that justice was done. The uncles were all there to see the, expression of joy in their faces. And then to the society, you could feel the reaction, and then it's also, it's an indication, the timeline within which this matter was concluded. It's only in election cases that you can conclude a judgment within 6 months. But here, we've been able to fast track the hearing, be it because I think the judiciary in the instant case, the investigating institution, the police in particular, did a very, very good job. We relied on, forensic digital evidence in proving our case, and then we are lucky because the Nasarawa State Judiciary had a platform, to facilitate this, digitalization of trials, and that helped in fast tracking the process of, proving the case against the defendant. So to a large extent, it's strengthened the belief in the judicial system, and then it also, gives a kudos to the judiciary for doing justice, and then it's a great relief to the society.
Now I'm talking about the precedents this would set going forward, particularly in Nasarawa State, whilst we wait pending the fact that 90 days would be given for any appeals. On the part of the executive in assenting to this, have there been previous assents by the executive in the state, and would this set a precedent in how the governor assents to it within the time frame that would be seen to give life to the judgment?
Well, for precedent, this current administration, I can't tell. There's no precedent in respect to, giving, giving effect to judgments, death sentences. But we want this to serve as a precedent, and we always encourage the government of the day to always ensure that for cases of culpable homicide of this nature, of this grievous nature, there should be, a form of implementation, a form of execution, so that the defender
Hello, Barrister Raymond.
will also have a bite of.
Hello, Barrister Raymond. Our network again. We lost some beats of your last comment there. If you could pick it up, if you're still with us.
And for us, there has not been precedent. However, we want this to serve as a precedent, going forward. We are going to write to the governor. We are going to recommend that this execution take place so as to serve as a deterrent and to justify the judgment, to justify, the shock, because this is one crime that, sends shock waves through Nasarawa State. And I want you to also know that the governor is following up with the event, and I believe is aware of the outcome, even though he's going to receive an official briefing on the matter. The Minister of Justice will do all it can within the legal framework to ensure that the judgment is executed. The commissioner is fully briefed and is on top of the matter, and then we'll do our best to get the judgment implemented.
Well, before we let you go, my last question is on your commendation for law enforcement. We are aware that the arrest of Salome Adaidu was made in Amwenserki in Orozo, a border community between Nasarawa and the FCT. What's your commendation to the security forces who acted on swift intelligence to apprehend? Well, we must apologize. Our connection to Barrister IRaymond Umaru has been quite one that has suffered some impediment this morning. But we also still would make attempts to speak to the Honorable Commissioner of Justice in Nasarawa State, Barrister Danladi. And as we make for that connection to be had, my last question to Barrister IRaymond Umaru was on his commendation for security agencies who apprehended Salome Adaidu shortly after he had committed that act and dismembered the late Salome's body into several pieces.
Recording stopped.
May her soul rest in peace. It's more so now on the precedents this would set in serving as a deterrent to those involved in such dastardly acts. Now, and whilst the case before the judge and the High Court in Lafayette was one that recorded evidence beyond any doubt, it is also in terms of the motive. Whilst in his defense, the defendant claimed that he was in a relationship with Salome and was led by rage over what he perceived was unfaithfulness on the part of the deceased in their relationship. It was quite condemnable, his decision to kill her in such a gruesome murder, and we continue to condemn such acts. Well, as an advocate broadcasting station, we would continue to give prominent coverage to these issues that border on social justice. Now, this is one that has been seen as justice served and the law has taken its course. But in terms of the implementation of the judgment, many Nigerians, much like the media, will be keen-eyed on seeing if the governor in the state would assent to this death penalty. Now, the defendant does have 90 days in keeping with the law, and on the section 221 of the penal code that is operational in northern Nigeria, one count of culpable homicide, it is indeed punishable by a death penalty. Now, would look to attempt to connect with the Honorable Attorney General and Commissioner of Justice, Nasarawa State, Barrister Isaac Danladi, who would join us to also speak about this in terms of the death penalty and the execution notice, as would be pending an appeal and an assent by the Nasarawa State Governor. Let's see if that connection is stable, and then would have him join us. But in the interim, we'll take a quick break, and when we return, we'll have that conversation.